Hello, everyone. My name is Ann Cleveland, and I am a paralegal at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Building from Baseline, Practical Advice for Strengthening Your In-House Home Health or Hospice Compliance Program. Today's presenters are Richard Pecore and Regina Moreno. Richard Pecore is a licensed Texas attorney with over 30 years of experience in personal injury and healthcare law. Mr. Pecore joined Lyles Parker as an associate attorney in January 2012 and became a partner with the firm in February of 2016. Mr. Pecore's practice focuses on Medicare and Medicaid administrative provider appeals and regulatory compliance plans for providers. Mr. Pecore's office is located in North Houston, Kingwood, Texas, and regularly visits clients in the Rio Grande Valley area. Regina Moreno, JD, CHC, is a healthcare regulatory attorney and compliance executive with more than 2 decades of experience in both the private and public sectors, and has served in key legal and compliance positions with leading healthcare and regulatory organizations throughout her career. Her previous service includes an appointment as a regulatory special counsel and ethics officer during the administration of then New York Governor George Pataki, Chief Legal and Compliance Officer for University of Maryland faculty physicians, and lead regulatory and compliance counsel for Excellis Blue Cross Blue Shield, New York's largest not-for-profit health plan. She is a frequent speaker for the American Health Lawyers Association and the Healthcare Compliance Association, and has been certified in healthcare compliance since 2007. Ms. Moreno focuses her practice on regulatory compliance matters involving virtually every type of healthcare provider, as well as workers' compensation regulations and strategic implementation of corporate integrity agreements for healthcare providers who have been subject to government enforcement. Now, without further ado, I present your speakers, Regina and Richard.
Thank you, Anne, and good afternoon. And Richard, good afternoon to you.
Good afternoon, Regina. It's nice to be with you again.
Thank you so much. One of our favorite things is the opportunity to go live and talk with our clients and folks out, healthcare providers out in the communities, and hopefully we'll offer some good advice today and some helpful direction. We did want to start with a disclaimer though. Richard and I are both attorneys, of course, with Lyles Parker, but we do want to make it clear that what we're talking about today really is general information only, to make sure that you're aware that legal advice, strategies, and outcomes do vary greatly, and they always depend on the facts and circumstances of your particular case. So this presentation does not constitute legal advice, and it does not create an attorney-client relationship. If you do think you need legal advice on any particular matter, we do encourage you to seek out and engage competent counsel from a licensed healthcare attorney in your area. Thank you. So the first thing we want to do is go over the agenda for today. Our title really encompasses practical legal advice or practical advice for strengthening your in-house home health or hospice compliance program. Really, this is applicable to any healthcare providers, but we've tried to tailor it to your particular area of practice. So what we're trying to do is help you identify some strategies and some practical advice so that in the event that you do have a government agency drop a subpoena on you, serve you with a subpoena, or even show up at your door and want to ask questions or gather information or documents, that you're in the best position to respond and protect your organization really as well as possible. So we're going to talk about your first lines of defense, really 2 areas we'd like to focus on, and that is optimizing and building out the strongest compliance program possible for your organization, and having strong contracts, which is a particular area of expertise for Richard, and he's going to talk about that in detail. He's going to also cover some of the various ways in which oversight agencies may investigate or review or examine your business, including prepayment reviews, ADRs, post-payment audits, and even payment suspensions. He's going to cover also from his experience as a litigator, he's going to cover subpoenas and search warrants and investigations and the fallout that can occur in any of those situations. And then I'm going to talk about excluded individuals, the importance of excluding, screening for exclusion, and why that matters to your organization and how to do that best. And then Richard will talk about Stark and anti-kickback, which is one of the key, two of the key regulatory structures that really set the rules for healthcare compliance and fraud and abuse, the self-disclosure protocols under each of those, and then a few words about HIPAA and some updates to HIPAA that may be of interest to you. And then, of course, you know, of special interest to the home health folks, patient abuse and neglect concerns, and then again wrapping it up with a discussion of some points regarding resolving the problem. So that's what we're going to cover today. I'm going to start. I'm going to take the first section here about advice, what to do when this happens, and then talk about some details around strengthening your compliance program. So again, what to do. What we're trying to do today is give you practical advice, helpful information that you can think about and strategize around how to make sure that you're in the best, strongest position in the event that you have a government agent who shows up to talk to you or your staff or serves a subpoena to your organization. So the first thing is don't panic. This happens with, unfortunately, significantly more frequency over the years, and really every corner of healthcare has dealt with and is dealing with government investigations and subpoenas and civil information demands and all of this. So don't panic. Just take a deep breath and be prepared. So the most important thing, particularly if an agent shows up at your door, is to get some information. So know what you're dealing with and who you're dealing with. Certainly ask them for identification, and don't put yourself in a mindset, an adversarial mindset. You know, be professional and cordial as you are in your everyday affairs there at work and in the workplace. But you know, do understand that you certainly are entitled to, and you certainly should get some basic information. So ask the person or persons for ID if you show up at your location. We say get copies of authority, meaning if they show up at your door and they have a list of what they're looking for, or they start asking you for documents, or ask for a computer, or ask for a key to a storage room or something like this, or ask for codes, the first thing you want to ask them for is, do they have a subpoena? So get a copy of a subpoena if they start asking you to produce things, and understand what are they asking for, what are they starting to take. Understand also, confirm, are they from the government, or are they a private contractor or investigator? And if it is the government, ask them, is this a civil matter or a criminal matter? This is information that'll be evident on the face of a subpoena or a civil information demand, a civil investigative demand, if they do show up. It's not something an average person might be able to glean from the documents, but you certainly could ask them that question. We say stop the bleeding, you know, that's a euphemism for don't make it worse, right? So yes, if you have someone showing up at your door, we do recommend that you call your attorney if you haven't done that right away as soon as they walk in. So wherever you're located, you should always kind of have in the back of your mind, who would you call if there was trouble, right? So try to have a sense of who in your area, um, has some expertise around healthcare or fraud and abuse, or has dealt with these issues before. Just have that in the back of your mind. If you don't have an attorney already engaged, try to have a good idea of who you would reach out to there, wherever you're located, for help at a time like that. And then we mentioned ask for ID, ask for the subpoena, ask for any documents, what we call the CID, or civil investigative demand. Make copies of that. And yes, you can make copies of their ID or ask them for a business card as well. You certainly can make copies of those things, and you should. And then anything that you're pulling for them, anything you're printing, any files that you're turning over, whether that is on site, someone showing up, or whether that is in response to a subpoena, make an exact copy of everything so that you know and your attorney knows what you have given to the folks who requested it. And that's going to be very important down the road. Understand what they have. It's going to be important so that you understand what they have, your attorney understands what they have or what might be missing. And you can often tell by what they're asking for what they're focusing on in their investigation. So all of that's relevant. So always make copies. And then notify your insurance carrier. Recommend doing this, right up front, not necessarily in the first 5 minutes, but you certainly want to do it within 24 hours. You want to let your carrier know that there's some sort of investigation, where it's coming from. You probably want to notify your D&O carrier, or most importantly, your D&O carrier, but even your general liability carrier sometimes is relevant. So, but above all, don't ignore it. Like if you get a subpoena, you don't want to say, I'm not answering that, or put it in a drawer, or hope that the government forgets about it. You definitely, you want to act on that. So, so that's all the first day. That's all what you want to focus on right away. So moving to the next slide, that's all well and good. Now the other thing I did want to mention, something important in terms of what to do the first day, or what to do when this happens. You should really have a cheat sheet with your receptionist or whoever is the first point of contact at your organization. Really should have a cheat sheet of who to call and what to do and if something like this should occur. So it should involve, for example, alert your compliance officer or your attorney, alert your chief executive or your chief operating officer, call your legal counsel if you have one, those types of things, what to do in the immediate sort of response. And if you have a compliance officer or you have an executive or an in-house counsel there, that might be the only thing you need to do, is to alert them and let them take it from here. But have a cheat sheet so that people don't panic and forget what to do. Thank you. So we can move on to the next slide now. So we talked about what to do if the unfortunate situation comes up, but what can you do before that to make sure that you're in the strongest position? And what you can do before that is to strengthen your compliance program and make sure that you are compliant with, and that you've got this covered. These 7 elements that you're seeing on your screen are elements that the Office of Inspector General, really the highest sort of law enforcement office in healthcare, is OIG. And OIG came out very helpfully years and years ago and gave us essentially 7 components of how to build out your compliance program, make sure it's effective. And this is important for 2 reasons. Number one, if you do all this, you'll have a strong program and you'll be less likely to run into compliance trouble to begin with. But number 2, in the event that there is trouble and there's enforcement and there's a settlement or there is a prosecution, when the time comes for the government to decide how much you would need to pay, or whether or not you're going to be required to enter into a corporate integrity agreement, or whether there's going to be maybe criminal prosecution. The more you can show them around how well you've done these 7 things, the better off you're going to be. They actually will take all of this into account in assessing, the extent to which there may be financial or other types of penalties. So for some of you, if you've joined us in the past, then this will be a refresher. For others of you who this may be your first foray into compliance, or your first sort of formal training, this may be new information. But this is how you do it from baseline. You start with written policies and procedures. You need a code of conduct. You need certain policies and procedures to effectuate all of the other elements. So you need a policy that establishes your compliance program. You need a written compliance plan. You need a compliance officer, a compliance committee. You need to designate, then you need to go ahead and hire or appoint someone on your team to serve as the compliance officer. You want to make sure that person has good training and experience. A lot of times providers, I've seen, physicians or nurses or pharmacists serve as compliance officers. That's totally fine. You don't always need a lawyer or someone, with that type of background, but you want to make sure that they have really good training. And then the compliance officer would chair the compliance committee, and you want to have a compliance committee that is made up of folks who represent really all aspects of your management team. You're going to need to make sure that you have effective compliance training and education, and that means at a minimum once a year, your employees should spend an hour with training that covers effective compliance programs, the leading and common fraud and abuse laws, risk areas in your particular area of practice, standards of conduct, ethics, and all of that. At least an hour. Really more is better, but your minimum is an hour. And you probably, if you have a sales team or a marketing team, you probably want to give them even more detailed training around do's and don'ts along the lines of outreach and sales, particularly to referral sources. You're going to want to develop effective lines of communication. So that means you need a hotline, and the hotline shouldn't just be, call so-and-so, call Regina or call Mary or call John at the front desk. It should be someone who is trained and experienced in receiving and acting on hotlines, and ideally, it really should be an outside entity. The government really looks much more favorably on the fact that you have a hotline to an outside source that's, an objective fielder of complaints and concerns than if you just had someone on your regular staff taking phone calls. You're going to want to have we say well-publicized disciplinary guidelines, and that means really you want to have your policies and procedures formally adopted, and you want to have your policies and procedures accessible. Just as accessible as you might have your employee handbook. They should be, if you have an intranet, they should be on your intranet. They should be not tucked in a drawer somewhere, right? They need to be visible and accessible for your teams. And then an effective compliance program absolutely has to have routine monitoring and auditing. So that means either your internal teams, and ideally to some degree you have external compliance audits going on where you're auditing your claims, you're auditing your coding, you're auditing your financial relationships, you're auditing your engagement with referral sources, and all these various risk areas. You're definitely going to want to have an auditing and monitoring program. You want to commit that to a work plan, so it's written out and it has it identifies who's responsible for the various for the various audit items and when they're due and how they're going to be reported and all of that. And then really important is actually responding. So if you find issues, you want to have a track record that's documented, that shows that you saw an issue, you responded to it, you corrected it, and you implemented some corrective action. So I spent a lot of time on this slide, and I'm going to speak a little more quickly for the slides that follow, because this is so foundational. This is such a key. These 7 elements are so critical to everything else you do, supporting compliance and protecting yourself against enforcement mishaps. So keep this one handy if you're a keeper. That's a good one to keep handy. So we can move on to the next slides. We talked about, we have a few slides here on certain risk areas, and this really relates to billing is such a high risk area, whether you're a billing company or whether you're a provider like a home health agency. How you bill is the key. And the reason why that's the key to compliance is because the government has gotten very, very good, and they have lots of resources where they can track trends. They have software programs that they run, and they track trends in your billing all the time. Medicare is doing this, Medicaid is doing this, payers are all doing it. So there are certain things that you want to always watch for. And this is why you want to have your own compliance auditing and monitoring process in place, because you want to make sure that you're not unbundling things that are bundled, you're not upcoding, you're not balance billing inappropriately, you're not ignoring overpayment requirements. And here's an issue, lack of integrity in your computer system. I can't tell you how many times, even with clients that are fairly sophisticated, have good resources, lots of money, they'll get into some trouble for miscoding something that, lo and behold, results in a lot of extra payment going to them. And they will get caught doing that, and they'll explain, this was a coding glitch. This was done inadvertently, so they'll be given an opportunity to correct. And then a year later, same issue comes up because there isn't appropriate compliance oversight in how they are setting up their systems. So all of that is important. All of those are risk areas, whether you're doing your own billing or whether you're farming that out. And then next slide. Just some additional areas of risk that you always want to keep your eye on in terms of billing. It's not just billing incorrectly, upcoding, unbundling, all of that, but you have to maintain the confidentiality of your records. And Richard's going to talk a little bit more about recent developments around HIPAA, but you absolutely have to protect the confidentiality. You have to be careful about outpatient services in connection with inpatient stays, things that are captured under a bundle, duplicate billing, that comes sometimes from carelessness, sometimes not. Sometimes it comes from not understanding appropriate billing rules for your payers. These are just some additional areas to look out for with risk. Joint ventures are always an issue. Be careful who your partners are, and be careful about partnering joint ventures with referral sources. And always be careful about waiving co-payments or co-insurance or giving discounts. If you are waiving co-payments, co-insurance, or giving discounts outside of a bona fide financial hardship policy that's applied equally across the board, is based on federal poverty level, requires documentation of income, all of that, then you are headed for trouble. And I'm going to strongly advise you against any of that, whether it's Medicare, Medicaid, or your payers, because we're seeing payers under state law, under contract law, now pursuing remedies against providers that are offering waivers. So next slide. Again, I On this slide, again, these are just things you could review, sort of do a spot check around making sure that you have, qualified coders, their training is up to date, they're not making assumptions about what they're coding, they're going back to the provider where there's any kind of a question about how something should be coded. You have to make sure that people are not altering documentation, and by that I mean, coders are not filling in extra information for the providers. Documentation is critical, and documentation has to be complete in order to substantiate a claim, and it has to be completed by whoever is doing the actual service. Make sure that your providers, your nurses, your NPs, your doctors, that their licenses are up to date, their certifications are up to date, and the time of coding that that whoever is doing the coding has all the necessary documentation, and isn't in a position where they have to chase it or guess. And then we'll talk in another minute. We'll talk about employment of sanctioned individuals. So next slide. Yeah, so, here's some more additional recommendations, particularly around billers. It really has to do with making sure your documentation is complete, making sure that it's accurate. Don't incentivize coding. Don't incentivize your coders to code higher or incentivize them with payments. If their claims are bringing in more money than the coder next to them, those sorts of things are really just way outside the realm of what's acceptable. Be timely, always be working your credit balances, always be reconciling your overpayments. Make sure that your data system is accurate and you have good, strong security around it, because the HIPAA security requirements are very, very important. Make sure that you're keeping records long enough and you're storing them appropriately, and so on. So just some additional advice there. Might want to keep that handy as well. And then there are, if you're doing your own coding, just skipping to slide 11, if you're doing your own coding, this is just helpful advice that Lyles Parker has come up with over the years around, ensuring 8 elements to ensure that your claim is payable. And by payable, we mean it's correct, it's accurate, it's entitled to payment. So medical necessity is the top one. Don't bill for things that are not medically necessary. Make sure the service or the supplies were actually provided. Make sure there were no other statutory violations, right, connected to the medical service. And by that, we mean improper incentives. Nobody's bribing anybody to get referrals. You have coverage requirements, right? Eligibility and coverage requirements for all of your payers, government and non-government payers. Make sure those requirements are met. Make sure that the service was fully provided or the supplies were fully delivered and all that was documented, particularly, for example, with DME. There's some close the loop requirements there on DME. Coded properly, billed properly, and properly paid. So if they pay you too much, pay them back what you were not entitled to. So that's the practical advice that surrounds the compliance piece. And I think Richard has some great advice for you coming up regarding your billing contracts and your contracts in general. So Richard, here you go.
Thank you, Regina. One of the things I mentioned is that when Regina brought up some great points at the beginning, when a government agent or someone comes to your door, one of the things you want to do is get ID. You want to find out who these people are. You want to see a copy of the subpoena. They have to, by law, give you a copy of the subpoena. If they don't, then there's something fishy going on. In any case, call your lawyer. And if you don't have one, go find one. Go talk to somebody. Most folks won't charge you for an initial consultation. Find someone you're comfortable with so you can call them in an emergency, because believe me, When that happens, you're not going to be spending time looking for somebody. You need somebody now, okay? So take it seriously. Remember that when you're in the healthcare business, you always have a silent partner that's not always so silent. And they're big and they're strong and they have a whole lot more clout than you do. So let's talk about contracts. The contract aspect is equally important when you're talking about your compliance program. Remember, the Affordable Care Act made compliance plans mandatory for physicians and groups like that, but it's being enforced for everybody. So if you don't have a compliance program, it's going to weigh in if there is another violation or problem. Your contracts are going to go hand in hand with that. So a billing contract should address many of the potential issues by delineating each party's right, obligations, and remedies. You're going to have an offer and acceptance. You're going to have compensation, but the compensation has to be legal under that state law. And we're going to talk a little bit more about that in a minute. It has to delineate what the duties and responsibilities are for each party, and it has to be dated and signed. If it's for longer than a year, it has to be reduced to writing. You need to have certain things in it when you're in the medical billing aspect of your contracting. You want to make sure you can get out of it if there's a problem. You need a termination provision. So if you have a provider that winds up getting audited, winds up getting in trouble, you want to be able to exit that contract so you're not providing services for nothing. If their funds are being tied up and it's going to be a while before you get paid, then that's going to be a problem for you. You want it to be able to handle requests for refunds. How do you resolve conflicts? You want to delineate who's responsible for credentialing, information that's going to be provided to you by the provider, because this is a cooperative effort here, hand in hand. Responsibility for coding, who's going to do it? Is it all on them? Who's going to check it? And of course, insurance. You're going to have E&O insurance and what that responsibility is. Next slide, please, Ann. So some examples of provisions that you want your contract right to of the biller, whoever that may be, if it's your service going in and providing the services, and as your home health and hospice going to be doing billing, to be able to conduct periodic on-site visits. You want to be able to audit the provider, make sure that what they're doing is up to snuff. This goes hand in hand with what Regina was talking about before, as far as knowing who you're getting into business with. Do a background check on them. Make sure this entity is legitimate. How many people have been gotten into a situation like this where they're providing services and they go looking for the actual office and it's not there? So make sure these guys actually exist and that you're not going to be out there, hung out on a limb. You've got responsibility for maintaining secure direct facsimile or secure email. You want to be able to have secure communications for HIPAA purposes. You want to establish a business associate agreement, and you can have this both ways. Each side can have one. The reason I recommend having your own is because you don't necessarily know what theirs says, and let's be honest, you're probably not going to read it. So if you know what yours says, you know you're good. Indemnification clauses are neat to have if you have those in there. You want to delineate that there is no responsibility to bill claims where there is insufficient or ambiguous support. If they don't give you the records to do the billing properly, well then, you need to be able to get out of that. And a compliance addendum, we mentioned doing complete background checks. The whole purpose of it is that you need to know your client is for real. You want to make sure that they have not been excluded, and Regina's going to talk about that a little bit more a little bit later. But these are all very important features. Next slide, please. So let's talk a little bit about billing agreements as far as complying with the law. From the federal point of view, the only restriction really on Medicare is the strange little exception is that if you have, the general rule is that only providers get paid. They get paid directly. There is an exception. For reassignments, the biller or billing entity, if that's a home health care or hospice company, agency, can be paid directly, and sometimes I've seen it where they cut a check back. Usually it's a very small entity that's doing that, and it's a small provider and they're providing that service for them. But you have to be careful. It cannot be based on a percentage fee basis. That's a violation of federal law. Many state laws also follow that principle. New York is one of them, and New York has extended it where they don't like percentage-based billing in any circumstance. State law limits, there's 50 states and there's as many different variations as you can think of. In my little quote there, you must choose carefully, grasshopper. Whether you're going to go, if you can't go percentage-based, then you have to choose between flat fee, hourly, per claim, or some other basis. There are states like Florida and Texas where you can use percentage-based billing for home health services if they're Medicare related, but not for Medicaid. So again, it's like walking a minefield. You need to get a healthcare attorney to help you walk that minefield. As I mentioned before, New York pretty much says no to everything. California pretty much says, oh, yeah, you can pretty much do everything as long as you do a couple other things like fair market value, and you don't tie it to referrals, and you don't exercise control over the entity. That's the direction these things are going, but we're not there yet. And you have so many variations to this. You really have to know what the state law is if you're providing out-of-state services. You also need to know what the provisions are for your state. Remember why this matters. 33 out of 50 states use a combination of these restrictions. The other 16, it's not that they don't have statutory or regulatory law in the books, it's common law. So it could be different still. The reason it's important is because states are going to penalize the provider, your client, for signing a prohibited billing agreement. And they could impose licensing fines, suspension, they could revoke their license, they could impose civil monetary penalties. In some states like Maryland, even prison. So this is serious stuff. There used to be no enforcement on this. Now it has turned around, and that's becoming an area where we are seeing increasing enforcement in many states. So the billing aspect has suddenly become very important. Be aware of it, understand that there are features that must be complied with, and it's going to be up to you. Next slide, please. So the most important thing, we're going to talk about prepayment reviews and ADRs. The first question you got to ask is, was this medically necessary? Your documentation is going to decide the claim. I think there's too many folks out there that look at it and they say, well, we provided the services, that ought to be enough. Wrong. If you don't sufficiently document it and support that medical necessity, you're not going to get paid for that claim. And if it's consistent and you do that consistently, you're starting to build a pattern of poor billing documentation that could lead to a much larger overpayment and a lot more problems. You want to know how to head off trouble before it happens. This is how you do it. The better your documentation, the better the chances you're going to get paid on each and every claim, and you're going to be able to keep your business liquid. You need to be asking the same questions Regina went over in how is a claim properly payable. There, where the service is provided, statutory violations of all coverage requirements have been met. It's been properly coded, properly billed. Is it supported by the documentation? Remember that you have a choice of billing method that's going to be guided by the type of state law you have and what is allowable. So, next slide, please. Your assistance on post-payment audits will be needed to pull, analyze, submit additional documentation. One of the questions you want to ask about your contract is, does it pay you for unexpected expenses? You need to be compensated for this, because if you have a post-payment audit, it's likely to be large. It could require 20 to 80 hours of time, as well as the cost of copies if they want paper. They don't necessarily always ask for electronic records these days. If you are faced with that situation, though, I would always suggest ask if you can provide it in that format. Most of the time they will let you, but if you do have to provide paper, it's going to cost money. You need to be reimbursed for that. Review the claims before you send the documentation in. It sounds simplistic and stupid to even have to say it out loud, but it's common sense. What if you're paid based on reimbursements or collections and payment is delayed? They have a payment hold. If there's a pre or post payment review, that's going to happen. Are you able to terminate the contract? Can you get out of it? Due to extraordinary delays in the appeal process, it's now 6 years to get to an ALJ and get a hearing date. It's very likely that they're going to start recouping any overpayment amounts before you get to that hearing date. How are you going to get paid if your provider's Medicare payments are being recouped and going into escrow? Again, you need to be able to terminate the contract, get out of it, so you're not being forced on the contract to provide services free. Whose fault is it if the claim is improper? Does your contract spell that out as far as the duties for supplying documentation? And have you provided incorrect advice to the provider? That's something you need to ask. Do you have E&O insurance? If you don't, why not? Don't forget, you have an obligation to repay overpayments within 60 days under the False Claims Act if you discover any errors. Now, that's 60 days from the date that the overpayment is determined. Understand that the process of investigating that overpayment to determine the length and breadth and width of it is also something that's necessary. And again, that's a situation if you discover significant overpayment that's more than, just a couple of claims, and you don't know how far it goes, that's the time to call counsel. And one of the reasons you do that is to get anything you should find after that under privilege. Very, very important. Next slide, please. Let's talk about suspensions for a second. From the provider's perspective, you have to get regular reports, monitor your biller, and not trust them blindly. You must make sure they are billing and coding accurately and conforming with the documentation you provide to them. And until you get to know your biller better, you need to check the correct codes, missing documentation and the like to keep them honest, or go on site, do an audit like your contract should allow you to. From the biller's perspective, you have to have cooperation from the client practice. Are you pointing out errors and omissions that they're not responding to, or basically just ignoring you? Is there something wrong with the picture that's going on here that's keeping the claims from being properly paid? Are any shenanigans going on? You start getting red flags and warning signs. That's something you need to know, as soon as you can determine it. Are you being asked to continue questionable billing practices that went on before you came on board that would compromise your integrity and, frankly, jeopardize the safety of your business? That's another situation where you might want to terminate that contract. Next slide, please. Subpoena, search warrants, investigations, and fallout, get a copy of the document. If it's a search warrant, again, they have to provide you a copy. If it's a subpoena, anything along that line, get ID, get the document, call your attorney immediately. And again, this is a case where you should have somebody in mind if you don't already have somebody on retainer. If it's a subpoena, you may have some more time to respond. Let your attorney work on the mechanics of that. If it's a search warrant, I want to say this right. You want to cooperate with them, but that doesn't mean turning on the mouth and letting it ramble. You don't get in the agent's way. You don't impede them. You don't obstruct. If you are asked questions that have to do with it, you either get your attorney on the phone or you take the fifth at that time. Don't try to answer questions other than routine type maintenance questions. Are you the person responsible for the documentation? You know, are you in charge of securing the documents? Who is the custodian of records? Things like that. Those are factual events that are not going to change. Be prepared to release a public statement reviewed by your attorney. Train your staff to deal with the questions. This goes back to the cheat sheet that Regina mentioned. Do not give interviews. That's just common sense, but you know. Do you have a business interruption contingency plan? What are you going to do if things go south and you have to close the door for a few days? Do you have a way to notify your other clients? Here's an example. Merida Health Group at Texas, January 2018. A licensed physician received $5,000 in kickbacks for referring hospice patients. When the investigation began, he called the individual who gave the kickbacks and told the individual to lie to the FBI if they were interviewed. When the physician was interviewed by the FBI, he also lied and denied accepting the kickbacks. When the indictment was unsealed, it was unsealed in 2018. Various individual trials were scheduled in July of 2019. They were both indicted. Don't lie to the FBI. They have too many resources. They're going to figure it out. Next slide, please. Regina, I think this one's yours.
Thanks, Richard. Yeah, we have a couple slides here regarding excluded individuals and the importance of screening for excluded individuals. So we have listed here the primary sites where you can go. You can do your own exclusion screening on the OIG and the GSA list and the SAM list. This is for folks who have government contracts. And then Medicaid, I think in 37 different states, Medicaid has their own lists that you can screen against in the particular state. So I always recommend, I use and have used for the past, I don't know how many years, going on 10 maybe, a subscription service where we actually upload every month to an outside screener, and they do the screening for us and send us a beautiful report at the end of the month. Those are always helpful. They're not actually that expensive if you shop around. So why is this important? This is important because, and actually I think I'm going to ask you to flip to the next screen. OIG has made it very clear that if you employ an excluded individual, anything that person has touched or possibly touched in your claim inventory essentially becomes tainted. So if you have someone in the billing office, or you have a provider delivering services, or anybody who has anything to do with touching a claim or has any involvement in the delivery of a claim or a service or a supply, and you find out at some point that they were excluded from Medicare or Medicaid, you're going to have to pay back all that money, anything that they touched, and this can be very expensive. So the better part, really, the better thing to do is to be screening for these folks on the federal list, on the state lists, and if you have, particularly if you're using a billing company, or an outside contractor for any part of your service or your billing process, you are going to want to make sure they are screening also, because if someone at your billing company is excluded, that all of the claims that they handled for you can be thrown out and likely would be thrown out. So you want to make sure that they're screening. There are two things I would recommend here. Number one would be to get a list of their employees and you do the screening. If they refuse to do that, which I've come across myself in the past, then you want to make sure they have a competent person doing the screening and they're sending you a report every month showing that their entire workforce is clean. We talked about what happens if you did use an excluded individual. That is very costly. And as I said, that really can and will taint every claim they've come in contact with. So the best way to reduce your liability is to be able to, first of all, catch it before it's a problem, do the actual screening and catch it. And if you miss something, which is possible, I had a case once where a doctor purposely misspelled his name, a referral source, and my client didn't catch that for months. So if you can show OIG that, well, we were doing the screening, and what happened here was this doctor purposely misspelled his name, we didn't catch it, or gave us the wrong date of birth or something like that, or the wrong social security number, then you're going to be a much more sympathetic case in that event. So screen, respond, make sure your partners are screening, and keep good records. That's my advice on exclusion. And I think there might be one more slide here, but these are just case examples, and you know, they just show you how this can go quite haywire if you're not on top of it. So please be on top of it, and you know, you can really help yourself a lot by taking care of this. So Richard, I think you're back on slide 22.
Okay, let me see here. Let's talk about Stark and the anti-kickback statute for a minute. In an example of billing for services not provided, an Oak Park, Michigan company created sham medical practices to submit claims for nerve block injections that were not provided to avoid prepayment review in his original practice, which is just hilarious. Family members, employees owned the fake practices, and the owner took 6%. He was sentenced to 10 years in prison, $3.2 million in restitution. Remember that Stark and AKS apply to billing services as well. Requests for any kind of kickback, referral fee, fee splitting, etc., should be refused. It's the safest, most sane thing you can do. Valid business arrangements, you need to document. You should involve healthcare attorneys to help you develop, document, and implement any business arrangements involving healthcare providers. A couple examples. Mary in Elmwood Park, Illinois, helped fabricate and submit claims for home visit physicians when the physicians rarely provided the service. She also submitted claims for deceased patients and employees who were no longer employed by the group. She billed for services through providers who were working in excess of 24 hours a day, which is a real trick. And she got 6% on the kickback. She was sentenced to 45 months in prison. Another example is Bonnie in Utica, New York. In 2015, Biller served as billing manager for a physician with offices in Nevada and New York and submitted claims on services on days a physician was not there. She was sentenced 15 months in prison, $2,500 fine, and almost $85,000 in restitution. Point is, even though these errors are almost comical, you will see more sophisticated sorts of things. They're the sort of errors and problems that enforcement is looking for. So knowing that the services were provided, knowing that they line up with the documentation your provider is giving you, is very important. If you start seeing things that don't add up, take it seriously. Dig into it. That's what you got your audit provision for. If you think you're in a situation you need to get out of, contact a lawyer, and they'll probably recommend you terminate the contract, and then you may want to take other steps to help protect yourself. Self-disclosure on slide 23. Self-disclosure is a remedy available to both providers and billers in situations where it's possible you might have civil monetary penalties. This is like using an excluded person, kickbacks under the anti-kickback statute, or self-referrals. Self-disclosure is not available for reporting straightforward overpayments. That's under the False Claims Act. And remember that a lot of states have mirror statutes. In fact, most of them do. If you go down the road of self-disclosure, be aware there are plenty of potholes. Now, I understand that the law says to report immediately. No, that's not a verbatim immediately. That's call your lawyer immediately. This is a negotiation, which means that before you contact the government, you need to be able to know what to tell them, which means, you know, how big, wide, far, and deep does this go? How extensive is it? What are we trying to cut a deal for? The last thing you want to do is give them an open-ended book, and now they're going to come in with a dozen agents and everything else. And not only will this probably last forever, now you've completely lost control over the situation, and you can't manage and get on with your life. So let's go to HIPAA. We talked about the BAA. Under the HITECH Act, BAAs are now required. Make sure yours includes the updated HITECH Act language. Remember that in states like Texas, covered entity is much, much broader than it is under federal law and pretty much includes everybody. So that was designed to include patient financial information for the most part. The BAA is meant to protect them, the patients, and not you, and not the people that you're contracting with. So you want to have your own agreement. Providers, make sure you fulfill your responsibilities under the BAA. You'll have similar responsibilities that are spelled out as you would under an engagement contract or billing contracts for services. And remember, it's not unusual for each party to have their own BAA. Again, I recommend having your own because you know what the content is. Case example, why to take this serious? There was a consulting group that got hacked. Over 2,000 patients had their PHI improperly accessed. OCR investigation went forward. These guys had 2 other breaches, and they wound up paying $5.5 million in fines. Next slide, please. I want to talk a little bit for just a minute about the update that's going on. December 2022 is when it's scheduled, but it'll probably happen further along, 3 months, 6 months down the road. There's a laundry list here of what you can expect to have happen. It's an expansion of patient access rights. They're going to shorten the length of time from 30 to 15 days. Texas already does that. So you're going to see a lot of these things that are actually already happening now as far as sharing information among common network providers. That's going to be enhanced. So they're just basically bringing it up to speed. Remember that CMPs are going to increase on slide 28. And there's the breakdown on it. There's the 4 categories. Just be aware that these will continue to increase. And let's mention patient abuse and neglect. This is such a huge area, and everybody's familiar with it. But one example is for Texas, anyone with knowledge of a suspected abuse and neglect of a child, an adult with disabilities, or an adult over 65 must report it to the Department of Family and Protective Services. That applies to all individuals and isn't limited to healthcare professionals. Remember that HIPAA is not an impediment to reporting abuse and neglect. Abuse and neglect takes precedence over privacy. And individuals who make reports in good faith are generally immune from civil or criminal liability for such reports. So let's talk about our conclusion here. Remember that what we're talking about here is improving your overall compliance plan and your contracts so you are in a stronger position to resist and avoid overpayments, legal entanglements that are caused from government investigations, audits, and the like. Now is not the time to pinch pennies when you talk about hiring the counsel. If you have a potential overpayment and you do not know how broad or wide this is, you don't know how big a problem you have. If it's more than just a couple of claims or so, you need to contact counsel immediately. You need to get it under privilege. You need to develop a strategy for dealing with it. You need to make sure that you are dealing with the fraud aspect of it so that you can either control it if it's not a fraud situation to keep it from migrating into one, or if it's a billing company in that case, how to approach the provider that you're working with and again determine just what's going on there. The consequences could be great. Privilege is critical to this whole process. You want to make sure that you have time to investigate the problem, determine how big it is, what the elephant looks like, how much money is involved, if there's a potential for fraud, if it's going to lead to an investigation, who else and how far might it lead to? Is it going to create other issues? If you don't contact counsel first, interviews could proceed without presence of counsel. They could be embarrassing, they could be damaging, they could even be incriminating. So you don't want to go down that road. We're just a little bit over. Regina, do you have anything else to add before we go to questions?
I'm good, Richard. Thank you so much.
Well, that concludes today's webinar. Thank you so much for joining us, and thank you to our presenters, Richard and Regina. Everyone from today's webinar will receive copies of the presentation slides via email. If you have any questions about today's discussion or another healthcare law issue, please feel free to reach out to Lyles Parker. Thank you so much.